Now we're good. Okay. Thank you everyone for bearing with us. Sometimes tech works really well, and sometimes we have to really make it work for us. So thank you again for your patience. Thank you all for joining. Again, my name is Maria Town, and I serve as the president and CEO of the American Association of People with Disabilities. Thank you all for joining today's webinar entitled Understanding and Protecting Your Disability Rights under Olmstead, the ADA, and Section 504. For a visual description, I'm a white woman with brown hair wearing a green dress and red lipstick. A few brief housekeeping announcements, and thank you all for being participants in today's housekeeping. This webinar is being recorded. You all will receive the recording after the conclusion of the webinar. We have CART and American Sign Language. To access the captions, please click the CC icon button on the toolbar at the bottom of your screen. If you experience any technical difficulties, as so many of you have already done, please communicate them in the chat. And if chat is not accessible to you, please email digitalcomms@aapd.com and we will try to resolve it. There will be time for question and answer at the end. So please type your questions into the Q&A chat box, which is also on the toolbar along the bottom of your screen. Recent Department of Justice actions have threatened to undermine disabled people's rights under foundational disability civil rights laws. This webinar is going to address the importance of the Supreme Court's Olmstead decision. It will address the rights that people have under the Americans with Disabilities Act and Section 504, rights that allow us to live in our homes and communities, and how recent actions from the Department of Justice may affect these rights. We're also going to talk about what we can all do to protect and advance these rights. The integration mandate of the ADA and Section 504 is one of the most fundamental rights that disabled people have, and it is critical that we take collective action to preserve it. Today's webinar will feature experts and advocates who have decades-long experience fighting for, advancing, and protecting community integration for people with disabilities. These experts are Jennifer Mathis, who is the Deputy Director of the Bazelon Center for Mental Health Law, Kathy Costanzo, the Executive Director of the Center for Public Representation, and Allison Barkoff, the Hirsch Associate Professor of Health Law and Policy at the Milken Institute School of Public Health at George Washington University. Say that 5 times fast. With that, I'm now going to turn things over to Jennifer Mathis, who's going to talk about the integration mandate. Thank you, Jennifer.
Thank you so much, Maria. So I'm going to give an overview of what the integration mandate is, where it comes from, and how it has been viewed by the federal government and by the courts. So the integration mandate has been with us for nearly 50 years at this point. It has been in the law since 1977. So the integration mandate first appeared in the HHS, Health and Human Services Department's Section 504 regulations for its own grantees. So the Department of Health and Human Services enforces Section 504 of the Rehabilitation Act, which prohibits disability discrimination by people and entities that get federal funding, federal financial assistance. So HHS issued the very first Section 504 regulations of all agencies in 1977. And in those regulations, it said that covered entities have to provide services to people with disabilities in the most integrated setting appropriate to their needs. That is what we call the integration mandate. And then after the ADA was passed in 1990, the Americans with Disabilities Act, the same integration requirement was included in the ADA's regulations in Title II of the ADA. That's the part of the ADA that applies to state and local governments. But the integration mandate was not just in regulations. It actually comes from the laws, the statutes themselves, the ADA and Section 504. So the Supreme Court made that clear in a case called Olmstead versus LC in 1999. In Olmstead, the court interpreted what discrimination based on disability means. And the court said discrimination includes unnecessarily institutionalizing people with disabilities when they could instead be served in the community. As many of you know, Olmstead was a case that was brought by two women, Lois Curtis and Elaine Wilson, who were confined in a state psychiatric hospital in Georgia for years, months, in one case, actually a little more than a year, in another case, several years after they were found ready for discharge. And they sued and they argued that the state was discriminating against them based on their disabilities by keeping them in the psychiatric hospital when they could live in the community. And the federal government weighed in on the side of Lois and Elaine in the Supreme Court. And the Supreme Court agreed with Lois and Elaine and affirmed that, in fact, unnecessary institutionalization is a type of discrimination that is prohibited by the ADA. And they highlighted two reasons why that's true. They said, first, unnecessary institutionalization severely restricts people's ability to do everyday life activities like social connection, talking to other people, socializing, employment, education, all of the things that people take for granted when they live in the community. And second, unnecessary institutionalization perpetuates, continues unfounded assumptions that people with disabilities who are institutionalized are incapable or unworthy of participating in community life, when that is not the case. So that is why the Supreme Court said this is a type of discrimination. And the court also looked at the language of the law itself, the ADA, not just the regulations. It pointed out that in the ADA, to put meat on the bones of what discrimination means, Congress actually directed the Justice Department to issue regulations that specifically incorporated the old 504 regulations, including the requirement that state and local governments provide services to people with disabilities in the most integrated setting appropriate. So the bottom line is the court said disability discrimination includes unnecessary institutionalization, and Congress had also specifically incorporated that requirement into the ADA itself. And it said also that states then have to provide community services where people with disabilities want them and they're qualified for them and where it wouldn't fundamentally change the service system. So after that, over the decades since the Olmstead decision, the federal government has embraced Olmstead and has actively promoted community integration for people with disabilities across every single administration, both Republican and Democrat, until now. So beginning in the Clinton administration, shortly after the Supreme Court's Olmstead decision, HHS began issuing a series of letters to state Medicaid directors where they explain the decision, they explain what it means for state service systems, and they offered states help to comply with the decision. And the letters provided guidance on all types of issues, such as what kind of a plan does the state have to comply with Olmstead? They offered strategies for states to promote community living. How can you use Medicaid? What are the different ways that you can expand community services? They announced changes in policy to make it easier for states to receive federal funding for community services. They highlighted new initiatives, such as partnerships between HHS and HUD to ensure that housing and services were available to people with disabilities coming out of institutions. I just want to quote from the first letter because it really illustrates what has been the federal government's commitment to Olmstead all of these years. And that letter that came out right after Olmstead said this decision confirms what this administration already believes, that no one should have to live in an institution or a nursing home if they can live in the community with the right support. Our goal is to integrate people with disabilities into the social mainstream, promote equality of opportunity, and maximize individual choice. So those guidance letters continued into the Bush administration as well, with the Bush White House launching what it called the New Freedom Initiative, where the president issued an executive order calling on the federal government to assist states and local governments to implement Olmstead. And it directed federal agencies to look at all of their policies, all of their regulations to determine what changes needed to be made to make community services more available. And so those efforts by the federal government continued through administrations since then, the Obama administration, the first Trump administration, the Biden administration, where the federal government has consistently helped states, encouraged states to comply with Olmstead, educate states about Olmstead, make clear what the integration mandate is and how you comply with it. And then the federal government has taken a leading role in enforcing Olmstead. So with both the Justice Department and HHS, they have used their enforcement authority over every administration to make sure that they're doing their part to ensure states are complying with the ADA. So DOJ began initially during the Obama administration by jumping into an existing Olmstead case that was brought in New York, and also by shifting gears in a case in Georgia that was brought as an institutional conditions case that was about hospital conditions, but they shifted gears during the administration to focus on getting people out of state psychiatric hospitals in Georgia and not just on the conditions in those hospitals, and also preventing people from having to go into the hospital if they could just get community services instead. So DOJ's enforcement efforts expanded from there, originally focusing on Delaware, North Carolina, Virginia, Rhode Island, Oregon, and other states. And then even during the first Trump administration, DOJ and HHS continued to enforce Olmstead. DOJ actually went to trial in two Olmstead cases during the first Trump administration in Mississippi and in Texas, and they entered settlements during that administration with West Virginia, North Dakota, and Louisiana. And then during the Biden administration, that enforcement continued. There were new settlement agreements, for example, with Colorado, Maine, Nevada, Rhode Island, Alameda County, a new agreement with Virginia, a trial victory in Florida, additional findings in Oklahoma, Kentucky, Nebraska, Alaska, Missouri, Iowa, Utah, and Alabama, among others. And then in addition to bringing its own cases, its own enforcement actions. The government also was very active in filing statements of interest, amicus briefs in other people's cases to advance the law and advance the clarity around the integration mandate. And HHS, in addition to DOJ, continued to enforce Olmstead throughout every administration, and they coordinated with other among HHS components. The Civil Rights Office in HHS coordinated with CMS, the Federal Medicaid Agency, and also with the Administration on Community Living, also with other agencies, with HUD, the Department of Housing and Urban Development, with the Department of Education, with the Justice Department, all to promote community integration for people with disabilities. So all told, the federal government became the lead enforcer of Olmstead. And then even in the current administration, until now, the federal government was enforcing Olmstead. They entered, for example, a new settlement agreement with South Carolina in 2025, and then one with Alabama in 2026. Now let me take us to the courts for a minute. Every court considering Olmstead has accepted that the ADA and Section 504 and Olmstead impose an integration mandate. No court has ever said otherwise over the nearly 3 decades since Olmstead. So as a result of Olmstead enforcement, tens of thousands of people with disabilities have transitioned out of institutions. Many other thousands have been able to stay out of institutions in the first place because Olmstead helped them to get the services they need in the community. And that's just enforcement efforts. In addition to those enforcement efforts, service systems across the country have expanded community services voluntarily because of Olmstead. And Olmstead has really been embedded into the DNA of disability service systems. There is no question we still have a very long way to go to comply with Olmstead, but federal and state Olmstead implementation efforts have made a huge, huge difference in people's lives. I'm going to turn it over to Kathy now to talk about this new DOJ memo and position and how it departs from the law and the federal government's longstanding position on the integration mandate. Kathy, you're on mute.
Kathy, you're on mute.
Sorry about that. Start again. I've been asked today to speak about the Office of the Legal Counsel. What is it, and what is this memo all about? And I just want to say it's one of those times where I really think the saying "don't shoot the messenger" is very appropriate, because this is a hot mess. The Office of Legal Counsel, and we're going to be referring to them as OLC today, is a component of the Department of Justice. It's essentially like an in-house counsel for the federal government. The office has the authority to advise the executive branch on questions of law. And so agencies, federal agencies, can take questions to them. If there seems to be disagreement between agencies, they can go to the Office of Legal Counsel for opinions. The Office of Legal Counsel can issue opinions, two different kinds, but in this case, they have issued something they consider a binding opinion, and it is only binding on the executive branch. Their memo, we're going to call it a memo rather than an opinion, because an opinion makes it sound like it's a court decision, and it isn't. The OLC memo was issued on June 18th, and its title, and I'm going to read it to you because it's not something that I would remember, is, quote, Application of Rehabilitation Act and Americans with Disabilities Act to State Institutionalization of Patients with Severe Mental Illness or Disabilities, end quote. Now, please don't misunderstand or feel a false sense of security that this memo has a narrow focus. It does not. This memo is not only about these groups of people, but rather applies to all persons with disabilities. And this memo is not only about state institutionalization, but rather addresses the responsibility of states to provide community services, raising questions about that, as well as raising the very constitutionality of the ADA in Section 504. Now, as Jennifer said, this memo is not the law, and it doesn't change the law. Only Congress can make laws, and courts would need to adopt it for it to become the law. So as Jennifer indicated, no court so far has adopted the extreme reasoning or analysis in this memo. In fact, the memo, one of its very accurate statements, one of the few very accurate statements in the memo, is that it acknowledges explicitly that all of the courts of appeal, which are basically right under the Supreme Court, which have addressed the issue of the integration requirements of the ADA in Section 504, have reached the opposite conclusion that the memo proposes. And in several pending cases, including some that my organization is involved in, the memo has been brought to the attention of courts, but so far no court has embraced it or even discussed it. And in fact, in one case in California, the court didn't even want to talk about it. So why this memo in the first place? What's really going on here? It's definitely part of the administration's agenda to address homelessness and to institutionalize people with disabilities. We think, though, that it also indicates that the White House wants the Supreme Court to address and probably overturn Olmstead, and that this memo basically lays out or establishes a roadmap for doing so. As Jennifer said, the Office of Legal Counsel is reversing almost 30 years if you're counting from the ADA, and 50 if you're counting from the Section 504 of federal policy and regulations. The OLC memo says that Congress did not have the authority to enact the ADA and 504 and require states to prevent institutionalization. So it had some authority to enact the ADA, but the requirements around preventing institutionalization and providing community services, the memo suggests that it went beyond Congress's authority. And it suggests that Congress may not have the constitutional authority to enact the integration mandate, but it claims not to have reached a final conclusion about that. Nevertheless, it's telling agencies that it should change its position and act as though the integration mandate is null and void. It also says that the Department of Justice and HHS did not have the authority to enact regulations that have been in place for decades. And those regulations were frequently required, at least in the case of the ADA regulations with the Department of Justice, required by the statute. And it was something, an authority given to the Department of Justice by Congress. And the clincher here, as I have indicated, is that the memo acknowledges on page 11, and this is the quote, "We recognize that this view of Olmstead's import is out of step with the common understanding within federal courts." Now, excuse me, neither Section 5 or 504 nor Title II of the ADA has an explicit requirement to serve people with disabilities in the most integrated setting, according to the memo. It explicitly says that Olmstead did not actually decide whether Title II and Section 504 require community placement for people with disabilities. It mischaracterizes Olmstead's holding and endorsement of the integration mandate by saying it was a minority view of the justice that was not binding, and this is not the case. It wrongly claims that the three-part test for community placement in Olmstead is not controlling. It invented a new interpretation of the integration requirement. So it's no longer the most integrated setting appropriate for an individual. It invents it, the new term that it invented was maximum integration. The memo then argues that the statutory mandate that states must treat people with disabilities in maximally integrated settings. Again, this is in no decision, no court holdings, would raise serious questions regarding Congress's power and authority under the Constitution. It then says that Olmstead only prohibits unjustified institutionalization, which means actual confinement in a facility, and that institutionalization is unjustified only where disability is the sole reason that the person is institutionalized, and that the state can't come up with a rationale that it can point to for why it's justified. So basically, anytime the state says it's justified and the person has a disability, it will, and they can come up with something other than just the fact that the person has a disability, it can justify the institutionalization according to the OLC memo. It further asserts that neither the ADA nor Section 504 authorizes agencies to put the integration mandate into their regulations, and has instructed the Department of Justice and other federal agencies to actually revoke their integration regulation and all applicable Olmstead guidance. DOJ recently filed a notice indicating that it was reviewing its Olmstead guidance that was originally issued in 2010 or 11 and revised in 2020. But they would not be enforcing that guidance, but they have not withdrawn it. So at this point, I'm going to turn it over to Allison.
Great. Okay. And it looks like we might have lost great, we're back. Okay. Hi, everybody. I'm Allison Barkoff. For a brief visual description, I'm a middle-aged white woman with curly brown hair, wearing a white blouse, and I have a background that says GW. And I'm going to pick up from Kathy, sharing both from my experience kind of as a law professor, but also from my time working, as Jennifer mentioned, inside of the Department of Justice. Both of us were leading Olmstead enforcement work there over the last number of years, and also being involved in regulations under Section 504 that fit into this bigger picture. So let me just start by saying that I know that this is really concerning for our community. It is really scary. There is nothing more fundamental than the right to be part of our community. And I think the fact that 700 plus people are on this webinar is really important. So I want to start by saying what this memo does not do. I'm really foot stomping what Jennifer said and what Kathy said. The Department of Justice cannot itself change the law or its interpretation. Only Congress can change the law, and only courts decide how laws are interpreted. The ADA and 504 have not changed, and the Supreme Court decision is still in place. And I'm going to spend most of my time talking about why it is so significant, actually stunning, that the federal government has reversed its long-standing, nearly 50-year commitment to the inclusion of people with disabilities, and why we as a community need to take action to fight back. So the first thing is that, as Jennifer explained, the Department of Justice is the primary enforcer of disability rights laws and Olmstead. And really, since the Obama administration in 2010, when this became really a top priority, people were brought in, we built an entire team. This has, across administrations, been something that the Civil Rights Division has focused on, and is especially well positioned when we think about big types of cases that are about changing entire state systems, what we often call systemic litigation. The cases since 2010 in particular have focused on working with communities, working with other disability rights lawyers, and looking at cases across so many different types of people with disabilities, whether it's people with intellectual and developmental disabilities, mental health disabilities, physical disabilities, older adults, children with complex medical needs or behavioral needs. And really, the Department of Justice was able to advance the law and really set models about how states should be working to make sure people were able to get what they needed to live, work, and participate in their own communities. This is very, very resource intensive work. And again, the federal government is especially well positioned to do this. They have historically partnered with disability rights lawyers, protection and advocacy agencies, and working with people in the community. Since this memo came out, just in the last 2 months, not even, we are already seeing the Department of Justice walking away from enforcing Olmstead. As Kathy mentioned, one of the first things they did was take this 2011 guidance that had been really important in helping states understand what their obligations were, helping people with disabilities know what their rights were. That was based on case law. And they have said, we are not enforcing that anymore. They have already started backing out of major cases in ways that are incredibly unprecedented, cases where the Department of Justice went to trial and won. And I'll mention 2 cases. One is a case in Florida involving children with complex medical needs, who were in or at risk of entering pediatric nursing homes. And because Florida was denying in-home nursing services. This case has been ongoing for years. It has gone to trial. And when it was on appeal, just in the last 2 weeks, the Department of Justice has said, we want you to send it back down to the district court because we don't agree anymore with the theory we brought the case on. The second case is a case in Texas involving people with intellectual disabilities who are inappropriately in nursing homes. Again, another case that went to trial, and now the Department of Justice filed something just in the last 2 weeks saying we are not going to be part of this case anymore. Thankfully, there are still private plaintiffs in this case, actually Kathy's organization, but they are walking away from cases they have invested in. We are also tracking investigations that have been opened and they are being dropped. And we are starting to see the Department of Justice in settlement agreements in Olmstead cases, again, starting to walk away. This is significant and impacts tens of thousands of people with disabilities across this country. And then finally, I'll mention, just in terms of DOJ as the enforcer, many of you have been part of webinars and advocacy activity about a case that was brought by the state of Texas, originally with 16 other states, challenging updated regulations from the US Department of Health and Human Services around Section 504. It's called Texas v. Kennedy. And this is a case where the case has primarily shifted to Texas, Florida, and now Alaska. Everyone else has dropped out, in part because of advocacy of people on this call, challenging Olmstead in particular. We expected initially that HHS, represented by the Department of Justice, would defend these regulations and would defend the long-standing, decades-long interpretation of Olmstead, and we now expect them not to be doing this. So again, these are some of the many, many ways that DOJ is backing away. At the same time, as I said, the memo does not change the ADA, 504, or Olmstead, which can still be enforced by private plaintiffs. Typically, that's done by protection and advocacy agencies and others who have been involved in this type of litigation. But I just want to mention, as I talk about what we're really worried about, which is courts adopting it, it's going to be very, very important for private lawyers and PNAs to think about how and where and what cases are litigated and be very careful in coordinating. The second thing that we are worried about and the impact that this memo has is either the Department of Justice or states trying to get courts to adopt the reading of the ADA, 504, and Olmstead that is in this memo. Like I said, the memo is just the reading and interpretation now of the Department of Justice. But we are already starting to see states, including Texas and Florida, taking this Office of Legal Counsel memo and filing it in court as what is called a supplemental authority. So saying to the court, look at this when you make your decision. Again, the memo itself acknowledges it is out of step with all courts to date, but some states have long desired to try to reverse or narrow Olmstead and get the Supreme Court to revisit the decision. And the way to do that is by getting a court to adopt it and appealing. As Jennifer said, DOJ has not yet filed a brief on the substance asking a court to adopt this view, but there certainly is a risk that they can in the number of cases that currently exist. And again, The Department of Justice not only can bring its own cases, but it can file briefs or even jump into private cases, which is why it is going to be really important for the legal community to coordinate and be thoughtful about litigation. Third, the memo sends a signal and is pretty explicit that both HHS and maybe the Department of Justice will be changing regulations and guidance. As Kathy explained, the memo takes the position that HHS, starting in 1977 with its integration mandate, with its initial Section 504 regulations, and the Department of Justice with its integration mandate in the early 1990s after the ADA was passed, the memo says neither agency had the authority to issue these regulations. We think that is wrong. We think Congress was very clear in passing the ADA itself that it reaffirmed those regulations and directed the Department of Justice to issue similar ones under the ADA. But this memo is very clear that we will start seeing regulatory activity by HHS and maybe by DOJ to undo these long-standing regulations. And Maria will talk more in a minute. We all have now have muscle to comment on regulations. We know that when agencies try to change things, it's going to be really important for us to share our story and why these regulations are important. But that is another thing that we expect to see coming from the memo. And I just want to mention that in the Texas v. Kennedy case, after the memo came out, the Office of Legal Counsel memo came out, the Department of Justice, on behalf of HHS, filed something with the court saying, now that we have this memo, we are talking with the cases that remain, the states that remain, Texas, Florida, and Alaska, to see what differences and what issues still remain in the case. And they said they would report back to the court at the end of August. So we expect that we will start getting some signals about next steps, and expect that the 504 regulations, which just put in the updated regulations, the long-standing case law on Olmstead, may be at risk. Finally, I will say the memo sends a message to states about cutting home and community-based services at an incredibly challenging time. As Kathy explained, the memo takes this incredibly narrow read of Olmstead, and it says that if the state has any justification for institutionalizing people, then that would not violate the ADA, 504, or Olmstead. Again, that is not the law. That is not what courts have said. But under that memo, if a state says we have a budget shortfall because we're getting less funding, because HR 1, the One Big Beautiful Bill Act, has cut funding, then that could be a justification. For a long time, Olmstead has been an important guardrail when states have considered cuts to home and community-based services, often requiring states to consider if there are alternative services for people who would be placed at serious risk of institutionalization. So right now, as states are navigating nearly $1 trillion in reduced funding from HR 1, this is the wrong message for the federal government to be sending to states. Finally, I'll just mention, before I turn it to Maria to talk about what the community can do, that there has been some significant efforts by the US Congress using their oversight role related to the Department of Justice and this memo. There was an oversight letter that was sent a few weeks ago from about 100 members of Congress, as well as a letter that was sent to the Department of Justice from the minority leaders of the part of the House, the committees of jurisdiction, the Judiciary Committee, Education and Workforce, and Energy and Commerce. There also was a Senate resolution. It's unclear how and if the Department of Justice will respond to any of this congressional activity. And there is a lot of work for us to do, not only in educating Congress, but in activity at the state level, because that's where this is really going to matter. So I'm going to turn it now to Maria. I just want to say again, thank you to so many people for joining. We will not go back, and our community has a lot of tools and strategies that we can use to continue to push back on this unprecedented rollback from a commitment that the federal government has had to inclusion for people with disabilities for decades. So, Maria?
Thank you so much, Allison, Kathy, and Jennifer, for sharing all of your knowledge, wisdom, and guidance. I want to provide a high-level summary of what all three of these incredible advocates have just said. One, Olmstead has been the law of the land, or the sort of presiding Supreme Court decision of the land, for close to 40 years. It's been supported by administrations, Republican and Democrat. This is not a partisan issue. The Olmstead decision, the ADA, and Section 504 all still exist. We still have rights. What has changed is the Department of Justice's position on enforcing those rights. But, and this is very important, the Department of Justice is one entity in the many, many entities that play a role in enforcing disability rights and making sure that people with disabilities can live and thrive in our homes and communities. We as disabled people also play a role in making sure that our rights continue. And that's what I want to talk about right now. So, what can we do in the face of all these threats and in the face of people just saying it doesn't matter that this has existed for 50 to 40 years? One thing that we can do that's simple is talking to our friends and families. A lot of people don't realize what it takes to make someone who is disabled be able to get out of bed in the morning. It's not just something that happens because it's right or nice. It's something that someone like me who may rely on personal assistance has had to fight for, and that programs and policies have had to be in place to make sure that I am not institutionalized. Having those honest conversations with people who love you or care about you is really important. It is surprising to see what our families and dearest friends may not understand about our lives as disabled people and what we have to navigate. There are 70 million more, even, disabled people across the country. It's going to take all of us to continue fighting for our rights, but it will also take our allies. And we need to make sure that our allies, again, the people who say they love us and care about us, are educated on these issues. So talk to your family members, talk to your friends about this threat, about the Olmstead decision and what's at stake. Similarly, we also need to be educating our state and local officials. There's a lot happening on this front already. Disability rights organizations have developed a statement that we are encouraging governors and attorneys generals to sign, expressing their support for Olmstead and their commitment to community integration for disabled people. When we send out the recording of this webinar, we will be sending out that statement to all of you, as well as resources on how to contact your governor and attorney general to encourage them to sign on to that statement. It is critical that policymakers hear and feel our collective voice and power as we are pushing these issues, and making sure multiple governors have expressed their commitment to Olmstead is a critical step. We already have governors who have expressed their commitment to Olmstead and condemned the Department of Justice's recent actions. Allison, we have this too at the congressional level. Allison already mentioned the oversight letters that have been issued. And there has been a resolution in the Senate led by Tammy Duckworth that has been signed onto by 20 senators highlighting the importance of Olmstead as well as condemning the Department of Justice's actions. There is a similar resolution in the House led by Congresswoman Debbie Dingell and Mary Gay Scanlon. Our champions need to be thanked and celebrated, and then they need to be further encouraged to get the rest of their colleagues to act. People with disabilities are a part of every single community across this country. There is no elected official who does not have disabled people as a huge part of their constituency. And so we should be seeing every elected official, whether it's a state legislator, state senator, or federal House of Representatives member or senator, expressing their commitment to Olmstead and community integration for disabled people. In addition, I want to share the importance of things like public statements, writing op-eds to your local papers. When we talk about these issues, we've already seen it today, they can get pretty wonky and pretty detailed. And a lot of folks think like, that's not really for my community. But in reality, at its core, Olmstead and community integration are what allow disabled people to be out and about in our neighborhoods. It is like the most kind of local issue we have because it's what enables us to just be in public. So writing op-eds to your local paper, posting on local blogs. I'm thinking about in DC, there's the Prince of Petworth. What does it matter if a restaurant is open if I'm not even allowed to be in the community, right? Anything we can do to further educate our community. One more systemic thing I want to mention, Allison hinted at this, are rulemaking opportunities. Whenever the federal government proposes a change to regulation and rules, oftentimes they go through what's called a notice and comment period. So they notify the public that that they are considering a change to a rule or regulation, and they often will give a period of time for people to comment about that change. You have an opportunity to say, I like this, and here's how I think you should do it. Or you can say, I don't like this, do not do this. Instead, change it this other way. The department has indicated that they will pursue rulemaking related to Olmstead. And we actually, and some of you have mentioned this in the chat already, have seen rulemaking on this front already. The Trump administration has taken many actions designed at reducing the number of unhoused people in the United States. And their goal has been to reduce unhoused people by increasing the number of institutionalized people. As Kathy mentioned, the title of this DOJ memo is actually focused on stigmatizing unhoused people with psychiatric disabilities or mental health disabilities. The justification for moving the Office of Special Education and Rehabilitative Services into the Department of Health and Human Services was actually to ensure that youth with disabilities don't wind up homeless. So this action is a part of a broader effort by the Trump administration to stigmatize unhoused people, and in doing so, stigmatize and erode the rights of all people with disabilities. So this rulemaking that attacks community integration or that attacks Olmstead may come from other agencies in addition to the Department of Justice. It may come from Housing and Urban Development, Health and Human Services, and more. So we need to be watching across the government for rulemaking that may threaten these rights. On a more individual level, I want to note that Voting Rights Week is coming up in about a month. It is the second week of September. Through AAPD's Rev Up campaign, our voting rights campaign, many of our state Rev Up coalitions will be hosting disability candidate forums. Anyone who's running for office right now, whether it's a Democrat or Republican, we need to get them on record saying that they will defend Olmstead, saying that they will defend community integration for people with disabilities, and how they plan to defend those rights. Finally, there is a new coalition launching right now called the Coalition to Defend Community Integration. It is a coalition for organizations, organizational leaders, as well as individuals, and it'll be a space for us to coordinate, to share resources, and to mobilize folks in order to continue defending and protecting our rights related to Section 504, the ADA, and the Olmstead decision. So I know that we have gone through quite a lot. Before we head into question and answer, I want to thank all of our panelists for their time and all of their work. I also want to remind everyone that this webinar is being recorded. We are going to send out the recording within a few days after we're done today, along with resources about everything we've talked about. These resources will include explainers that break things down into plain language, the statement that we want to encourage governors and attorneys general to sign, as well as guidance for how to reach out to your state leadership. And we will also share more policy analysis resources and more, as well as the sign up link for the coalition that I just mentioned. So with that, we have 30 minutes, which is great because we've got a lot of questions. We're going to open it up for Q&A, and I want to start with a question that can go to everyone, and this is from Bob Williams. Bob writes, the memo indicates DOJ will no longer enforce the integration requirements. What could that mean for individuals, ongoing litigation, states, especially with regard to Medicaid? And how can we document and challenge the damage it might wreak?
Maria, I'm happy to start and then others can jump in. I don't know if maybe we need to pin all of us. I'll wait just one sec. Okay. So I think I answered some of Bob's questions, which I know he put in the chat before I spoke about what the different implications are. I'm going to put in the chat something for those of you who are interested in tracking what the Department of Justice is doing. We have a longtime colleague who actually started right around when I was at the Department of Justice building the Olmstead Enforcement Program, who then stayed on until she was one of the people pushed out of the Civil Rights Division, as so many great lawyers were, who has started an initiative called Red Line for Civil Rights that is tracking all of the places where this is specific to the Department of Justice Civil Rights Division work, where they are dropping cases, where they are dropping investigations, where they are changing positions. So I'll put that in the chat. It's called Red Line for Civil Rights. Bob also asked the question about the tie-in to Medicaid. And, as Jennifer talked about, Olmstead has been kind of an impetus in many ways for states investing in home and community-based services. And now with the cuts in Medicaid from HR1, we are very concerned that without these guardrails, states may be cutting more. I will also put in the chat a initiative that I'm leading called the HCBS Impacts Tracker, where I'm working with several other organizations, not directly related to Olmstead, related more to HR1, and looking at what is every state doing in terms of their HCBS system. So Bob, those are two different ways that people can track from the civil rights side and from the Medicaid side. I'll put it in the chat, and I'm sure Jennifer and Kathy have more to add there.
Jennifer,
Yeah.
go ahead.
Thank you. So yeah, Bob, those are all great questions. And I would just add to what Allison said that in terms of, how do we challenge what DOJ has done? I think there will be plenty of opportunities where you will see those challenges happen. I think we would like to minimize those opportunities for states to even bring those kinds of arguments to courts. It's going to be in courts where this happens. I think DOJ, we are seeing is, shutting down a lot of its Olmstead work already. And it, will be states, it's going to be up to states to do the right thing or not. And that is one of the reasons that it's so important for us to try to get that commitment, get governors and AGs to join that statement saying, we're not going to join in these attacks on the integration mandate. We're not going to do what DOJ has done, because that will, I think, minimize the opportunities for this to happen. But I would just say that certainly the easiest, or the ways that we, will be most likely to prevail are where we are in cases where there are actual facts. And so I think where you are most likely to see some of the legal challenges happen are when this actually comes up in cases where there are actual facts and the cases that people have brought, as opposed to kind of abstract challenges. Like, that's why in Texas versus Kennedy, I think there are, reasons why it makes sense right now to let things play out. And that is a sort of an abstract challenge. And so if you don't see the Olmstead lawyers racing into court to do something, I think, there's usually a reason why it is strategically important to do this the way we're doing it. But we're always happy people can email us to if they're concerned about, any particular challenges where or any particular cases where this is coming up. And certainly in terms of tracking, we are trying to track all over the country where this is being brought up, where these arguments are being raised and the memo is being cited, but always welcome anybody funneling that information. Sometimes there is something that we don't know about.
Going back to Bob's question, we're seeing at CPR two different ways in which this is manifesting at the moment. In several of our cases that we have currently pending, the Department of Justice has filed a notice, or a state has a notice to the court informing them about the OLC opinion. And to date, no court has taken action on any of those, but it's just probably a matter of time. And so we're preparing to defend the positions that we've taken all along in the case, and to speak to the inadequacies or the many problems with the OLC opinion. Beyond that, the Department of Justice has just withdrawn from a case that we litigated with them almost for about a 6-week trial, but in Texas, and won and got an amazing 400+ page opinion with amazing facts about people with intellectual and developmental disabilities improperly and illegally confined in nursing facilities in Texas. DOJ has just indicated and filed papers with the court asking for permission to withdraw from the case. And, frankly, if they can't be constructive, we're just as happy to see them go. But obviously, losing them as a partner, a valued partner for many years, is a big loss. And I think that we're going to be seeing that. And what that will mean is that it will put a burden on other private attorneys, organizations like Bazelon and CPR and other, DREDF, others, and that there's going to be a limit to how many cases we can actually take on.
Thank you all so much for your responses to Bob's questions. We've got lots of great questions coming in. I'm going to move to another one from Brian Fisher. Brian asks, although less efficient, if for no other reason than it lacks consent decree authority, is the private attorney general doctrine viable in this instance as the DOJ walks away from the enforcement table?
Yeah.
Yeah, Jennifer, let's start with you.
I can start with that. Yes, and actually, private lawyers can enter consent decrees too. It's not limited to the federal government, the United States. They tend to do more consent decrees, but certainly private lawyers have litigated these cases for many years, and they are still around. And there's the P&A system, lawyers, the protection and advocacy agencies. There are groups like ours, like Basilon and DREDF and CPR and ARC and others that have litigated these cases. And so we're not losing the entire ability to enforce Olmstead just because the federal government is stepping out of it. But I would just say I think we need to be careful. And this is a time when things feel incredibly risky, and a lot's going to turn on what happens, I think, in the next year or so, what the courts do. And so I think we are all proceeding pretty cautiously right now, and people should think about that. I think Allison mentioned that people should be careful right now in doing this, given all the risks that are at play with this opinion.
Allison or Kathy, do you want to add to that?
Yeah, I'll just add one thing, because people may be thinking about private rights of action and be following it in different contexts. Um, in other types of statutes like Medicaid, there's been a lot in the courts in some ways that have narrowed the ability of people to be able to come in and file a private lawsuit. In both the ADA and 504, in the statutes itself, it actually gives a private right of action. So all the questions that exist in other types of contexts there, as Jennifer said, there is no question that private lawyers can bring lawsuits here. And as Jennifer said, and just to foot stomp what I said several times, we need to be really careful in thinking about what courts, what issues, the right cases, and coordinating as a legal community, as we did before the DOJ got very engaged. But again, we have a very the judiciary the courts are changing a lot, and really because the Supreme Court is setting a lot of different rules that have made it harder in a lot of these cases. We just need to be very careful.
Before we move on to our next question, one of the questions that I saw come in was someone basically asking, what do we do if we live in a state that has a governor that's very much in alignment with the administration? And I want to just reshare what was said about the Texas v. Kennedy case. That case started out with 17 attorneys general who were all in lockstep with the Trump administration. And in large part, thanks to local disability community advocacy, there's now only 3 attorneys general on that case. And so I've seen a number of questions asking, like, what difference is individual advocacy going to make? And I just want to emphasize individual advocacy on this front can make all of the difference. We cannot allow ourselves to become completely disheartened, even though it is very tempting and there are many reasons to feel that way. I am heartened by the fact that there are hundreds and hundreds of people on this webinar and close to 2,000 signed up. We may not have, it may not feel like we have a lot right now, but we actually have each other, and that is incredible. And I also just want to remind everyone, I once lived in Texas. Texas helped to really establish the idea of supported decision making as policy. Lots of red states have histories of doing great things on disability rights. And those governors and attorneys generals who have maybe forgotten about that history or maybe never known about it should be reminded. And we can do that education. So let's go to another question from a specific person. We have a question from Mary Moore. On what grounds could a person be institutionalized if it is not related to a disability?
Yeah, I mean, this goes to something that was really fundamental that maybe we all take for granted, but when you read the Supreme Court's decision, historically, when you think about discrimination, you compare how people in a protected class are treated compared to someone who isn't. So if it's discrimination based on gender, how are women treated compared to men? If it's based on race, how is someone who's Black compared to someone who's white? And one of the things in the Supreme Court's Olmstead decision was actually the exact question that you raise. And in actually Justice Thomas's dissent, he says, I don't think that's institutionalizing people based on their disability is discrimination, because it's not like we're institutionalizing non-disabled people. I think the two things in the memo, Kathy talked about both. I think the one that they take a very different read is they say if the state can come up with any reason, and of course a state can always say, we have a lot of people, we have a lot of people's needs, we have budget shortfalls, we have a lot of things, then it's okay. I think that is what is most profound. But again, like I think they're really harping in on this idea, and that you have to show for every single thing that a disabled person is treated differently only because of their disability. I think that could be, potentially true in some contexts and not in others. That is not the way that disability law has been read to date. So again, just to emphasize, these are very extreme views that I think really reflect kind of a broader view that the Trump administration and the Office of Legal Counsel have had about narrowing civil rights protections in general. I mean, this is not the only memo that OLC put out. They put out something very similar around race discrimination that is it takes something that is very fundamental, that people, it's not just intentional discrimination, but discrimination when you have policies that disproportionately impact groups of people. So I would just say, to answer your question, this is part of a broader attack on long-standing theories of civil rights, and they picked these couple things to lean in on in ways they hope courts might narrow the law, but they are not the law yet. And Jennifer, I don't know if you or Kathy want to add to that.
I don't really
We can
have
talk about
much to
different
add
impacts.
other than that if they were correct, that if OLC were correct, that the discrimination had to be solely on the basis of disability and not on any other reason that the state could come up with, Olmstead would have come out the other way.
Mm-hmm. Yeah. And I think that there are always things that people with disabilities are accused of, like for people, like in the title of this thing, people who are perceived, very wrongly as being dangerous or needing to be cared for or requiring the kind of restrictions that certain environments impose, like institutions. So, if you need help with your activities of daily living and you have a disability, is that enough? Maybe under their formula it is. And, that's definitely like just despicable.
Thank you all. One question that we have from Teresa Anderson. Teresa asks, when do you expect to start seeing the changes or repeals of regulations and rules, and how can we stay informed about that?
I think we will start to see that soon. Certainly with HHS's 504 regulations, because that is the subject of the Texas versus Kennedy litigation, and because the federal government has now indicated that essentially its position is very much aligned with Texas's, I think we can expect that HHS will move forward with some kind of rule change. What exactly that looks like, we don't know at this point, but that seems like the most likely thing to happen first. DOJ might do something similar with its integration regulation. We don't know yet, but given that litigation happening and the fact that it's about those 504 rules, I think that's the first thing that we're going to see in terms of how people can stay plugged into that. I think you will see from AAPD, from DREDA, from all the groups, a lot of information coming out when, and AAPD will certainly let everybody know how to comment when those rule changes start to happen, if they start to happen. And we'll have templates, etc. And it will be very important that people weigh in.
And just to be concrete, when a regulation is changed, it has to be published in what's called the Federal Register. That's the official way that it gets shared. So we will all let you know as soon as that happens. It actually goes on display in advance. There's different ways that we can track that as that's going through the rulemaking process. But as Jennifer said, we think that we will likely start seeing some signals potentially around rulemaking for HHS in the filing that we expect in the next few weeks. But the rule itself has to be published in this formal kind of way, and we will all make sure that gets out very widely.
Thank you all. We've gotten a few people asking if the presenters could explain how this memo might result in a decrease or end of funding to disability services organizations, which may result in folks losing access to services and supports that they need.
Yeah, I think we often talk about Olmstead as being everything about community living. And so I want to say the reason why we have 3 lawyers as panelists is this actually is about a law and how courts are interpreting the law. But Olmstead has really been the wind behind lots of broader changes like Medicaid and states investing in home and community-based services. And I saw some questions about what would this mean for SIL funding. So as someone who was leading the federal agency, the Administration for Community Living, that funds centers for independent living or PNAs, protection and advocacy agencies, or DD councils, those are totally separate. Congress is the one who actually sets funding for most of the disability programs, not Medicaid, most of the disability programs that we are talking about. And even with Medicaid, they set the rules around Medicaid, for example, HR 1, the One Big Beautiful Bill Act, where they made changes to Medicaid, that is different than ADA and Olmstead. Although again, Olmstead, we would often come in if a state was making changes or cutting services for people that place them at risk of institutionalization. So they have an intersection, but I think for people who maybe are running an agency and are worried, how is this going to directly impact their funding? That is something that is separate from this. And it's not about everything that relates to community living. I don't know if Jennifer, you or Kathy want to add to that, but I saw some speakers worried about their organization's direct funding, which again is appropriations from Congress and different from this.
Yeah, and I would just say with respect to, I see a question about, in addition to funding for SILs, funding for SILAs, which is, I think that person's in Illinois, but I'm not sure they may have the same title elsewhere, but sort of community living arrangements, that, that's a particular sort of designation in Illinois and maybe elsewhere. And there, I think, this doesn't directly impact, what a state may choose to do with its disability service system. But I think the concern is if states get the message that they don't have to comply with Olmstead anymore, either because they think this is the law or because they think that they're just not vulnerable anymore, then they may be more likely to cut the community services. Our view would be if they did that, then they are still going to be potentially violating Olmstead, and Olmstead still is the law. And so maybe DOJ is not going to sue them, but other people might. They would still be vulnerable. And so it doesn't change directly, I think, what would happen with community services.
Thank you all for explaining that. Our next question is from Paul Grossman, and to me, this feels a little bit related. Paul asks, is there a serious chance that the effort to resegregate people with disabilities will impact implementation of least restrictive environment in elementary and secondary school settings? And
Yeah, I'll just say that Olmstead has been applied actually not just to traditional institutions like nursing homes and psychiatric facilities, but it actually has been applied. Jennifer and Kathy and I have all been part of a case applying Olmstead in a state that set up a segregated school program and system for students with behavioral health disabilities. And so they are completely different laws. So we should be really clear if you are bringing cases under the Individuals with Disabilities Act and the least restrictive environment, no matter what happens in Olmstead, that is a separate law. And a lot of things could be brought under both IDEA and Olmstead, especially when you're looking to make broader systemic changes. So I would say on the edges, there are some ways that we have been using Olmstead maybe in the last decade to try to, instead of, make change individual student by individual student, do bigger, broader change, what I call systemic litigation using Olmstead. I think that could be at risk here, but I want to make sure anyone who does IDEA work and special education, continues to understand that that is a separate law that is not directly impacted here.
great. Kathy or Jennifer, do you want to add to that at all? I want to go back to the notice and comment aspect of rulemaking because we've got a good question, which is, will the regulatory rule changes be in the form of interim final rules to avoid the public comment period? And for folks who may not follow the Federal Register as closely as the panelists and myself, lately we've been seeing the administration issue interim final rules that are final the day that they treated as final the day that they're posted. While there still is a comment period, the rule kind of becomes final. And so, could we see this happening as it relates to community integration for people with disabilities? Jennifer, Kathy, Allison, what do y'all think?
I think we very well could, just because we have seen that over and over and over again, that this administration has moved forward with interim final rules, with direct final rules, with various mechanisms, various ways to uh, dispose of the notice and comment process that is designed to give the public an opportunity to have input, and that requires the agency to consider that input. I don't know. They may actually do it with a notice and comment process, but given what we've seen, given the track record, it is certainly well within possibilities that they will do it as an interim final rule. They have also done this in a number of rulemakings that involve Title VI, where they are saying that because this is about federal financial assistance, that they consider that there's an exception in the APA, the Administrative Procedures Act, that says they don't have to do notice and comment where it involves grants and loans, etc. And so we've seen them invoke that. They may try to invoke that with Section 504 rulemaking, but either way, whether they do it as an interim final rule or they do it the way they should with notice and comment, it's really important to comment. I think if they do it as an interim final rule, there usually still is a comment period, and we should absolutely be all over that.
And I'll just mention that, regardless of whether there's comment on a rule, that Jennifer mentioned a law called the Administrative Procedure Act that allows you to challenge regulations if they're illegal, meaning they conflict with the statute, if they are what's called arbitrary and capricious, meaning that they're not based on evidence, they don't consider factors like longstanding reliance on the prior rule. So again, no one needs to do anything yet, but if and when this happens, we will want to get everybody out, AAPD and others will put out model comments, and that provides a way for lawyers to think about ways to challenge rules, whether they go through regular notice and comment or go through an interim final or something like that. So there's many steps and many different strategies. We're not there yet, but I think just making sure people leave today knowing this is really significant, and there are many ways that people can get engaged. And as the cards start falling in different ways, we'll continue to update the community on how we can continue to fight back.
Thank you so much, Allison, Jennifer, and Kathy, again for being with us today. Thank you to everyone who signed up for and participated in today's webinar. We got so many great questions. As we are right at the 5:30 mark, I want to again say we will be sending out the recording of this webinar along with the transcript. We will also, with that recording, send out all of the resources and advocacy opportunities that were mentioned today. That includes the commitment that we want folks to get governors and attorney generals to sign on to, guidance on how to contact your state officials. We'll send out the oversight letters and resolutions that have been issued so you can see if your representatives have signed on and can encourage them to do so in the future. We'll also send out information about the HCBS impact tracking that Allison mentioned, as well as plain language resources and much more. There's been a lot of great wisdom shared in today's webinar from our panelists, as well as from all of you. There is so much that we can do together to protect disability rights, protect community integration, and protect one another so that we can create a nation where we can all thrive. So I'm going to end today on a hopeful note, encourage all of us to lead on and express my deep gratitude to everyone for making today's webinar such a dynamic conversation. Thank you.